back on the record in case 2014-3. And we will now next take up issue number 1F. And that reads, does the Board of Adjustment substitute its independent judgment on matters of law and determine sections 11 and 12 of the 2005 Planning Board decision were judicially reinstated by operation of law under the 2010 court decision? Could I have a motion, please, a positive motion, please?
Bob, go ahead.
I think I...
Mr. Stewart?
Okay. Move that the Board of Adjustment substitute, we're on 1F, right?
Yes.
Move that the Board of Adjustment substitute its independent judgment on matters of law and determine sections 11 and 12 of the June 1, 2005 Planning Board decision were judicially reinstated by operation of law under the April 2, 2010 Supreme Court of Alaska decision, and that's cited as Anchorage Board of Adjustment versus LBJ LLC, 228 Pacific 3rd, 87 at page 93.
Mr. Haxby, will you second that?
I'll second it.
Okay. Mr. Stewart?
Well, at first blush, this appears that the Supreme Court of Alaska affirmed the Superior Court decision, which reversed the decision of the Board of Adjustment and reinstated the June 1, 2005 Planning Board decision. And I think we have the Planning Board decision. Hang on just a second. Well, in the Planning Board decision, it might come down to deciding what is the decision and what's a finding of fact, because it says in that Planning Board record, it refers to findings of fact and decision. So I guess it remains a question as to whether or not the decision that was reinstated is in fact a decision that includes the findings of fact and would include the amendments on those findings. But at least on its face, it appears that the entire decision is reinstated.
Okay. Mr. Haxby?
Pass from me for a second, Aaron.
Okay. I must tell you, I'm not sure that it does. And I don't think I'm going to vote in favor of the motion. And here's why I'm saying that. When you look at the LBJ decision, on the very last page of it,
You talking the Supreme Court or?
yes, page 93, conclusion. The conclusion starts out, first of all, by saying the district has agreed from the outset that it was subject to Title 21 of the Municipal Code. Period. While it is true that significant effort in the administrative proceedings was devoted to issues of traffic and safety, and that the planning board did not directly rule that Yosemite Drive was an urban collector, it does not appear that there's no other way to read the record. And then here is the important part as far as I'm concerned. Accordingly, the issue presented in this appeal is more narrow. Must a subdivider upgrade a road to the standards set forth in AMC 2185-030A when, prior to approval of a final plat, the road is found to be a collector road in an urban improvement area? Question mark. I conclude the answer is yes. While a traffic study might be used to require improvements to a road not designated an urban collector, it cannot be used to dispense with those required by the code, at least not without going through the variance procedure. Accordingly, the decision of the Board of Adjustment is reversed, and that of the Planning Board is reinstated. To my way of thinking, what that means is, remember that the Planning Board said you need a subdivision agreement that you need to enter into regarding the upgrade of Yosemite Drive. The Board of Adjustment then said, no, it was the other way around. I'm so sorry, I'm getting it mixed up.
They said
the Planning Board said, you enter into a development agreement for the construction and for the upgrade of Yosemite Drive. The Board of Adjustment said, no, you only need to do a subdivision agreement if the TIA finally finds that you need to do that, the upgrade, that is. And of course, we know that the TIA didn't require it. So, the crux of the matter, to my way of thinking, is that both the Superior Court and the Supreme Court very narrowly looked at the issue of required upgrade. They did not at all address the issue of subdivision agreement versus development agreement. And so, as I read the Supreme Court decision, what was reversed was the Board of Adjustment's decision not to require an upgrade to an urban collector status unless TIA required it. And both the Superior Court and the Supreme Court said, no, that's wrong. The code requires you to upgrade it. And that's what you need to do. And it is for that reason that we reinstate the decision of the Planning Board, because that's precisely what the Planning Board had said. And so, for that reason, I do not think that the issue of subdivision agreement versus development agreement was ever addressed by either court. And so, for that reason, I do not think it was incorporated when the Supreme Court said the decision of the Board of Adjustment is reversed and that of the Planning Board is reinstated. It simply addressed the substantive issue, but not the method of getting there. And so for that reason, I tend to think that the determination of the Planning Board that it should be that the requirement to upgrade Yosemite Drive should be contained in a development agreement, I don't think that was mandated by the Supreme Court. And in fact, it would be illogical to assume that it was incorporated, because the Supreme Court said several times ASD is a subdivider, and as a subdivider it's subject to the requirements of Title 21. One of which is that you need to enter into a subdivision agreement.
Right.
Not a development agreement.
Yeah.
Okay. So I do not believe, and I would vote against the motion that sections 11 and 12 were fully incorporated. Sections 11 and 12 of the 2005 Planning Board decision were judicially reinstated fully by the Supreme Court. Now, I could change my mind depending on what Mr. Stewart comes up with, but that is how I'm looking at the issue at present, I must tell you.
Can I comment here?
Of course. Mr. Haxby.
This is really complex. However, throughout the Supreme Court decision, and I think that I think that what it states in here is that everybody understood that they would be treated as any other subdivider under municipal code, and it states that in there. And I think it says, but it is difficult to understand exactly how the standards might have been thought not to apply, given the understanding that ASD would be treated as any other subdivider and the straightforward language of the municipal ordinances. And it further states, as was observed above, ASD has not argued that it should be treated differently than any other subdivider. LBJ built the road to the required standard within its subdivision, and the district is essentially being held to the same standard, albeit a longer stretch of the road and in context that evolved over time. So, my thought process is simply that the Superior Court and the Supreme Court said, you're just like anybody else. You're required under AMC, it's plain, straightforward, and simple. You have to do the same thing everybody else has to do, period. Now, on the other hand to that, I think the municipality failed in their agreement. So what I'm saying is that, is it judicially reinstated?
The substantive part of paragraph 11 of the 2005 Planning Board decision, subsections A through H, recite the standards required to bring the road up to snuff to an urban collector standard. I think we would all agree to that.
Yes.
And it seems to me that is what the Supreme Court and the Superior Court said. You need to bring it up to the standards of the urban collector. You cannot do what the Board of Adjustment did, which was simply say, you shall enter into a subdivision agreement with a private development section for construction of any road improvements that may be required by the final approved traffic impact analysis. So the Supreme Court said, no, you need to bring it up to the collector standards under the code, not dependent on whatever the traffic impact analysis says. Okay? But it didn't address the subdivision versus development agreement, the subdivision agreement versus development agreement issue. Never got to that issue.
No.
And neither party apparently ever argued it. So I don't think that portion of it was incorporated. And it was was reinstated of the planning board decision of 2005. Only the result was, but not the method of getting there.
That wasn't an argument in the court cases, but it was in the record. LBJ brought it up. They need to execute a subdivision agreement. LBJ brought it up.
But it was never addressed.
It wasn't addressed. It was not addressed by the Superior and the Supreme Court, but it was addressed by LBJ in the record. They said, the fix is easy.
And to continue with that, it was addressed by the Board of Adjustment, which says you need to enter into a subdivision agreement.
Yeah.
When the planning board had said, no, you do a development agreement. No, the planning board was the one that demanded a development agreement.
Yeah, the
And the
planning
Board of Adjustment
said no.
mandated the subdivision agreement.
2005 planning board.
Yeah.
Yeah, exactly.
So that's why I'm saying I don't think the method of getting to the upgrade, whether by subdivision agreement or by development agreement, was ever addressed. I just don't think it was. Or at least it was not decided. Maybe it was addressed by LBJ. I cannot recall. But at least it was not addressed by the Supreme Court or the Superior Court in their decisions.
Other than the fact that they said you shall be treated as any other subdivider. And under Anchorage Municipal Code, any subdivider, governmental entity or other, shall enter into an agreement, a
Subdivision agreement.
That's correct. So they're saying Supreme Court and Superior Court said you will be treated as any other subdivider. Anchorage Municipal Code is clear.
That's true.
And
So-
Anchorage Municipal Code states you will enter into an agreement. You're going to be treated like everybody else, then you're going to enter into a subdivision agreement.
So what you're really doing is you're reinforcing my argument that they never mandated that it be a development agreement.
That's correct. They did not mandate it be a development agreement. They're saying, follow the code, go back to code.
And consequently, getting back to the motion, it is not true that sections 11 and 12 were fully judicially reinstated by operation of law under the court case. Isn't that what follows?
I think so.
Mr. Stewart, where am I wrong here?
Well, if you read it literally, in the narrow interpretation, the school district has to bring the road up to meet the standards in 030 or 030A.
The urban collector standard.
Right.
Yes.
That urban collector standard, well, there's a lot of things in there, but includes the drainage and road improvement generally. It doesn't necessarily go into exactly what's in here, because some of this is from other documents that the city uses.
But isn't the 2005 planning board decision that specifies in 11, A through H, the standards that need to be met in reconstructing or in upgrading the road?
For the improvements to the existing road, yes.
And doesn't that satisfy the urban collector standards? I think it does.
Yeah, and I think that's what the planning board also deemed, that it would suffice for those standards.
And the Board of Adjustment said, no, you don't need to do that. You just follow what the TIA says.
Which is incorrect.
And the Supreme Court held that it was incorrect.
That's exactly
But the
right.
procedure that the Board of Adjustment utilized to comply with the TIA was correct, which is a subdivision agreement, not a development agreement.
Yeah, you see, they mixed it up.
Yeah.
That's what they did. They mixed it up. So the standards, the standards, the basic standards that were specified in the planning board decision for the street were correct. But they screwed up and didn't require a subdivision agreement, which provided for the warranties, the bonds, the funds, everything else, and a timeline with a hammer for enforcement.
Okay,
Okay, so that's
All right.
that's the basic fact.
okay. So now let's come back to the motion. The motion is that all of sections 11 and 12 of the 2005 Planning Board decision were judicially reinstated by that 2010 case. I don't think that is true, because paragraph 11 of the 2005 decision starts out by saying, entering into a development agreement for improvements of Yosemite Drive, etc., etc.
Exactly.
And it is my view that the court decision did not incorporate that particular sentence.
Nope. It did not. They said you're going to be treated as any other subdivider under AMC.
Okay.
Period.
That does make a significant difference.
It does.
Doesn't make sense? I think it does.
I agree wholeheartedly.
And you see, the reason that is important is because the real conundrum that I was facing initially when I looked at this case was, well, what in the world are we going to do? Here's the Supreme Court that said you need to have a development agreement when the code says you need to have a subdivision agreement. Well,
The Supreme
as you
Court
look
did-
at closer, as I just said, and I think that's the gist of the motion, the Supreme Court did not say you need to have a development agreement.
Yeah.
You merely need to reach an agreement in conformance with a code that accomplishes this result.
Precisely. Precisely.
All right, now getting back to the motion.
Okay, let's read the motion, let's talk the yea and the nay,
All right.
so we got it now.
And, Mr. Chair?
Yes.
Yeah, as indicated before, this is something that you may want to have the vote on this motion as stated, and then you may want to have a new motion that restates what you just said.
Exactly.
Okay.
Thank you. Thank you for clarifying that. The motion is, the Board of Adjustment shall substitute, or substitutes, its independent judgment on matters of law and determines that sections 11 and 12 of the 2005 Planning Board decision were judicially reinstated by operation of law under the 2010 court decision. That's the motion. And I will vote against it for the reasons that I have outlined.
Okay, I'm going to, I'm going to vote against it just because I see now that if you use the term development agreement like they had here, I think the Supreme Court would have said something about it, but they did not.
It simply didn't occur to them.
No.
No, they said to go back and follow the code.
Yeah.
Have a nice day. See
But
you.
here's the decision you need to come to.
Right,
You need to upgrade.
yeah, exactly,
Okay?
in accordance with
So-
code.
Yeah. Okay, any further discussion?
Okay, so okay. Okay.
Are we ready to vote?
We are?
Yes.
Madam Clerk?
How do you vote? Baron Goodchow?
No.
Robert Stewart?
Nay.
John Haxby?
No?
The motion fails by vote of 0 to 3. All right, as our esteemed lawyer suggested, we need to have a follow-up motion to clarify what we meant by turning down the previous motion.
Baron put it into
And
words.
so I will move that what was incorporated into the 2005 planning board decision was the result, which was that the ASD needed to upgrade Yosemite Drive to urban collector standards, but the Supreme Court decision did not specify the method of reaching that result. Does that make sense?
And for my clarification, is that a motion to substitute your judgment?
Yes.
And find,
Yes.
as you stated?
Yes.
Thank you.
Run that by me again, Baron.
The Board of Adjustment substitutes its independent judgment on matters of law and determines that only that portion of sections 11 and 12 of the 2005 Planning Board decision was reinstated that referred to the obligation of the Anchorage School District to bring Yosemite Drive up to urban collector standards. It did not refer to the method whereby the school district had to accomplish that.
Or did it?
What I'm struggling with is to come up with a distinction between development agreement and subdivision agreement.
I understand.
Yeah, and
So we take
It was a
judicial
little-
notice, we substitute our independent judgment on matters of law and determine that the Supreme Court did not mandate a development agreement to accomplish the upgrade of Yosemite Drive to urban collector standard.
okay.
Isn't that a simpler way of putting it?
That makes a better distinction,
Okay,
because we're having problems with the issue of the
Development agreement.
development
subdivision.
agreement used in section
We're gonna
11
get to
of
that.
the 2005.
I think we will get to that.
We'll get to it.
So, did anybody make notes of this?
I
Did you?
I wrote as fast as I could, but in truth, I didn't get it all.
Run it again, Baron, it's all right.
I could restate what I
Okay.
wrote down. I wrote down that the motion would be, does the Board of Adjustment substitute its independent judgment on matters of law and determine that the Supreme Court in the BOA Anchorage decision did not mandate a development agreement to accomplish the goals, to accomplish, and then my shorthand is...
The upgrade.
Thank you, the upgrade of Yosemite Drive to urban collector standards.
Did
Yes.
not?
Did not. The Supreme Court did not specify that. Did not specify that it had to be a development agreement.
Okay, and that's what it is.
Yes,
Did not specify it needed to be a development.
yes.
Okay, it had nothing to do to urban collector standards or anything else. Did not specify it was going to be a development agreement.
Yes.
Okay.
Are we clear on the motion?
Yes.
Mr. Stewart,
Yes?
are we ready to vote on it?
Yes.
Madam Clerk?
How do you vote? Baron Goodchild?
Yes.
Robert Stewart?
Aye.
John Haxby?
Yes.
Okay, the motion passes 3-0, and it should be clear that the intent of the motion, I know it was difficult to follow it, was that we substitute our own independent judgment and are saying that the Supreme Court did not mandate the use of a development agreement to force ASD to upgrade Yosemite Drive to collector standards. All right. Now then, there is another issue that we skipped earlier,
1H?
and that is 1H. And that issue is, does the Board of Adjustment substitute its independent judgment on matters of law and related facts supported in the record by substantial evidence and modify the Planning Board's 2014 decision to further condition preliminary plat approval in this case on ASD satisfying standards in sections 11 and 12 of the 2005 Planning Board decision? Can I have a positive motion, please?
Go for it.
You wouldn't do that?
Sure. I move that the Board of Adjustment substitute its independent judgment on matters of law and related facts supported in the record by substantial evidence and modifies the Planning Board's 2014 decision to further condition preliminary plat approval in this case on ASD satisfying standards set in sections 11 and 12 of the 2005 Planning Board decision. May I have a second, please?
Second.
All right. I made the motion, so I will address this issue. We have already decided, or we have found, I should really say, that sections 11 and 12 were not incorporated in whole by the Supreme Court decision. And consequently, it is not true to say that the standards, that all of these standards in sections 11 and 12 should be incorporated into the 2014 board decision. Because what that would mean is, in effect, that we are again mandating that the urban collector standards be arrived at by way of development agreement, and that we have already decided is not the case. So for that reason, I intend to vote against the motion. And I now know that Julia is going to say you need to have a follow-up motion if that motion fails, and that's what I intend to do. But for the purposes of resolving this issue, 1H, I intend to vote against it. Who seconded the motion?
Think I did?
Okay,
I'll vote no discussion.
okay. Mr. Stewart?
Just clarify for me again, you're moving to modify sections 11 and 12?
That's where we are heading. That's clearly where we are heading. But we need to first state that 11 and 12 are not to be incorporated in full in the 2014 decision of the Planning Board.
This is a follow-up
Because-
from the previous motion with the
Yes,
with the
because it
courts.
would then require a development agreement.
Right. So what we've done is we've said, okay, we said the Supreme Court doesn't reinstate it because it doesn't specify a development agreement. And so now we're coming back and we're saying,
We are not incorporating those two sections into the 2014 decision.
Okay.
Does that make sense?
Yeah.
Okay. Let me just look at this because I made the motion. I want to be sure. Okay, I'm ready to vote. Any further discussion?
none.
Madam Clerk?
How do you vote, Baron Goodrow?
Nope.
Robert Stewart?
Nay.
John Haxby?
No,
The motion fails by a vote of 0 to 3. Now, we need to have a follow-up motion. And I'm wrestling with that in my own mind. Because having said that the full sections are not incorporated into the 2014 decision, we need to somehow, it seems to me, say what we want them to say, which is that conditions A through H, the urban collector standards, that should be in the 2014 decision.
that's correct. That should be in there.
And then the question is, how is that to be accomplished?
Exactly. Okay, so do we wrap it up into one motion? Or do we say that this, because we ought to get it, we ought to get it all.
Can we get it all in one motion? What's your thought on this whole issue?
I'm thinking that, if I'm understanding the direction correctly,
Just
that
grab
the motion would look a lot like the prior motion. That is, that the motion would be, does the Board of Adjustment substitute independent judgment in matters of law-related facts supported in the record by substantial evidence and modify the Planning Board 2014 decision? And then...
By adding.
Yeah, and then the question, for me, is, will these be conditions of preliminary plat approval?
Well, I think we can address that later on. I think that's what it should be, but
What we're really saying is that, okay, we agree that these conditions, A through H, shall be included.
Then you shall enter into a subdivision agreement.
You shall enter into a subdivision agreement. But keep in mind that one tiny issue here is that we've got drainage improvements that are included into a development agreement that's already in force. So how do we tie that one up? Okay, because we've got two competing entities here. Okay, we all agree that it sounds like we're all agreeing that A through H need to be included.
And that addresses only the road standards.
That's
Yes,
correct.
Road improvement.
That
Yes.
includes the road improvements, and in order to do that, they need to execute a subdivision agreement. So that's where we're headed with this at the end of the road. Okay, so we want to get there. The only issue that we're going to get stuck on is the drainage, because the drainage is included in this development agreement. Do we have to void the development agreement?
We can't do that.
Okay, so what they have to do is they have to enter into a subdivision agreement, because if they don't,
So how about simply saying, we will add as a condition the requirement that you enter into a subdivision agreement that encompasses the upgrade, the road upgrade, and the drainage issues identified in the development agreement.
well, we want to get the hell away from the development agreement language. We want to we want to shove this down the subdivision agreement road.
Well, but that doesn't mean that we cannot adopt part of the,
It's part of the record.
yeah, I know, I'm
Right, I guess
just looking at this.
The question that I have here
Yeah.
is that in the development agreement, under section 1, the A section, you compare that, and so A 1 through 8 as you pointed out, is the same
Yep.
as in there. So the development agreement includes, you know,
Hey, Baron, hold on.
Wait, just one second. Let me finish.
in there. What Mr. Haxby said in opening comments, I understood to be that a subdivision agreement can refer to and incorporate a development agreement. Did I misunderstand that, Mr. Haxby?
Well, here's what I'm concerned about, is that, and you guys are the lawyers, so you're gonna have to kind of clue me in on this, okay? They have a development agreement. It's not in conformity, we can't interfere in that development agreement. They've got an agreement, okay? However, we can further incorporate the requirement that they enter into a subdivision agreement which incorporates that. So we're not abrogating their development agreement, we're pulling it into a subdivision agreement, and therefore what they have to do is that they have to put the bonding, they have to do the warranty, do all that stuff.
I have the solution. When you look at the subdivision agreement, the development agreement, it identifies the projects by number. It says ASD project number 865007, Yosemite Drive upgrade.
Okay?
And then it says PM&E project number 07-54, Yosemite Drive drainage improvements. Why don't we simply say that the subdivision agreement shall incorporate completion of those two projects?
Plus, the other
No,
requirements...
no, you don't refer to it.
Well,
Because,
yeah, but the subdivision agreement has to incorporate the other elements of AMC.
okay, of whatever it was, 2108-060.
That's correct, including guarantees and funding and all
okay.
that stuff.
Okay, so why don't we, I think we're getting someplace, so that we say we are amending the 2014 decision by adding, I'm sorry?
We call it modifying. You get to modify. You have the jurisdiction to modify.
I'm just a pro forma. Okay, so we modify the 2014 decision by adding condition J, that's the number. If you look at the 2014 decision, it ends at I, and we add J, to require ASD to enter into a subdivision agreement with MOA that provides for completion of ASD project number 865007 and PM&E project number 07-54. And other requirements under 2108-060. How's that?
Run that, other requirements under 21.0.
2108-060.
Can I read that that I have to make sure that I have what you're talking about?
Okay.
So this would be
We substitute,
that the that the motion would be that the board substitutes its independent judgment on matters of law and related facts supported by substantial evidence in the record to modify the planning board's 2014 decision by adding condition J to require ASD to enter into a subdivision agreement pursuant to AMC 2160-080.
No, 2108-060.
060, sorry, getting dyslexic there. To enter in a subdivision agreement, to require ASD to enter into a subdivision agreement with MOA pursuant to AMC
2108-060
060
for the
completion
completion of the two projects that
of
I
project
numbered.
number 865007 and PM&E project number 0754.
Now, let's just talk about this.
Yeah,
Let's just talk about this. Is it, if we mention PME project,
yeah,
then it's going to come back to PM&E saying, back to the Supreme Court case where they say we can't guarantee ourselves.
no. That's not what we're saying. We're saying ASD needs to enter into a subdivision agreement
For their portion.
for those two projects. And the projects are identified. One of them is the road upgrade and the other one is the drainage upgrade.
Touche.
But
Touche.
So the only thing we need to make sure of is that the condition, so that they don't, I don't want to use the term weasel out, but
That's
they
what they've
need to
been doing.
complete, well, they need to incorporate all of the required terms of the subdivision agreement as required by
Code.
2108-060.
Absolute.
Okay,
So just to tie that back in then, I think that you have the motion to substitute the independent judgment of the BOA on matters of law and related facts, supported by substantial evidence in the record, to modify the planning board's 2014 decision by adding J to require ASD to enter into a subdivision agreement with MOA pursuant to AMC 2108-060 for completion of Yosemite Drive upgrade projects ASD number 865007 and PM&E project number 0754.
okay.
Read it again.
And it needs to incorporate also the other conditions of that section.
Yes. All other conditions.
After the preamble, modify the 2014 decision of the planning board by adding condition J to require ASD to enter into a subdivision agreement with MOA that provides for completion of ASD project number 865007 and PME project number 07-54, and for other required,
Do we have to get rid of development agreement out of their section, their preamble in 11? We have to get rid of the terms.
well, just a second, we are now dealing with this motion to incorporate, to require them to do a subdivision agreement.
Well, I was thinking that
Okay.
when you say the pursuant to,
No, that should come later, because
Okay.
they need to add all of the other requirements that are contained in that particular section.
So what we're really saying, Baron, is that we need to say, we're going to modify instead of entering into a development agreement, they're going to enter into a subdivision agreement and incorporate A through H. That's basically what
Yeah.
we're doing.
No, that doesn't cover it. What about the drainage issue?
Well, that's true.
See, that's why I referred to the project.
Okay.
Because they identified project.
But development
So-
agreement is still in there under section 11.
Yeah, that's
that's- That's an
What do you
issue.
mean? No, it is not.
So what you're saying is, so let's read the motion again. Entering into a subdivision agreement in accordance with
Right.
21.08.060
To provide for,
to incorporate ASD Project 86507 and 07-54. Period.
and just leave it at that. How about just leaving it at that?
Well, I think when you say the subdivision agreement,
Entering into a subdivision agreement in
And I think-
accordance with 21.08.060, incorporating ASD enters into a subdivision agreement
To provide for the completion of those two projects.
to provide,
Yeah,
I think that totally cleans the bill.
yeah. Don't need to say anything further. Does that make sense?
But Howard,
Do we know, and just a second here, hold on.
There is a problem, but we need to get over this hurdle first, and then we can address the next problem.
Do we know that 86507 and 07-54 include everything that's in here?
Well, that's what they contracted for. It contains the upgrade to the road, look at section 1A, and in B, it refers to the Yosemite Drive area drainage improvements.
Okay, so do we need to specify as at a minimum, as stated under section 1, the projects?
No, I don't think so. We just referred to the project numbers.
yeah, if you refer to the project number and then indicate that it's the Yosemite Drive drainage improvement,
If you
et
want to.
cetera, I think that needs to
I
be in
don't-
there.
That's fine, that doesn't trouble me at all. It's just,
Okay.
they have in their, the usual administrative, bureaucratic manner, they have identified these projects already. And they have to describe. Now,
Well, but do we know that ASD 86507 is described as this project?
yes,
Section 1.
it says Yosemite Drive upgrade.
As MOA.
And under section 1A, it says, you need to upgrade it to these standards. So we know that the project, ASD project number, contains exactly that.
Then why don't we just identify that? The ASD Project 86507, under Section 1A, and PM&E Project, well, I
Sure,
guess,
that's fine, I don't care. So what we are doing, if we pass this motion, I need you to be aware is that we are requiring ASD to complete both projects.
yep, as they should.
Well, wait a minute. This thing here says MOA will do the drainage.
They can enter into a subdivision agreement, and if there are provisions within code which state that that there's a cost sharing, that the muni can identify the cost sharing, that portion of the project that is paid for
Okay.
by the
By MOA.
municipality, and that part that is paid for by the subdivider.
Okay,
Municipal code already has
Okay.
that in writing,
okay,
so that's okay.
all right,
I agree.
okay. Are we ready to restate the motion, just so that we are all on the same wavelength?
Let's restate the motion.
Okay, all right. Julia, you need to help me here. The Board of Adjustment substitutes its independent judgment on matters of law and related facts supported in the record by substantial evidence and modifies the Planning Board's 2014 decision to further condition preliminary plat approval in this case by adding condition J to require ASD to enter into a subdivision agreement with MOA pursuant to AMC 2108.060 that provides for completion of ASD project number 86507 in parentheses Yosemite Drive upgrade, close parentheses, and further described in section 1A of the development agreement of March 22, 2013, and project PM&E, project number 07-54 in parentheses Yosemite Drive drainage improvements, close parentheses, as described in section 1B of the development agreement of March 22, 2013.
Aaron, before you go, hold on that. Did you say preliminary or final plat? You said preliminary, I think.
Yes, he did.
And
I
think-
said, because that's what it says, approval of preliminary plat.
Where?
That's, I'm looking at the 2014
2014.
decision that says, approval of the preliminary plat for 18 months subject to the following conditions. How does that square, you are right, how does that square with what we found before?
The code, you see the code, what the code says is before a final plat.
So why,
The code states,
so do we make this instead of a little j, do we make this paragraph 3 and say before the final plat can be approved?
before the final plat can be filed or approved or filed,
Approved or filed?
because that's what it states right in code.
Yeah. I'm concerned about,
We don't want to get a language issue wrong here,
no, that's true.
because that's going to be deadly. It's just going to set another $250,000 worth of lawyers' fees and another 10 years delay. Now the ASD pushes it off into.
Well, this will probably get appealed anyway, but anyway, Julia, do you agree that's what it should say? Should refer to the final plat?
Well, I think that that's what, as you discussed and pointed out here, that's what the code
Mandate. Yeah.
requires them to do.
And that's what the Supreme Court said, follow the code.
Yeah.
The Superior Court said, follow the code. You gotta treat it like everybody else, follow the code.
Right, I think that what you may be recalling is from the briefing on in the reply brief filed by the appellants, because ASD brought up the point that the code says final plat approval, not preliminary plat approval, and so my paraphrase of what the appellant's brief was is that, yeah, but in the facts that we have here in process, the final plat approval is, I can't think of the word, is ministerial. And it's and that the only hook you have is to do it is to do it as a condition in the preliminary plat approval.
Yeah, but-
And then that sort of relates back to what John said, Mr. Axby said in the beginning, is that normally the fail-safe in the system to avoid this isn't the preliminary plat approval, and as Barrett said, also as Mr. Guchow said, it isn't the subdivision agreement, which happens after you have it. It's in the certificate of occupancy, it's not being opened.
You see, they can't even,
All that, they can't do business. And then the problem that the board will grapple with at some point about that is that the remedy for that they didn't do business, that they shouldn't be doing business.
They should shut the school down.
Probably isn't here before the Board of Adjustment. That's in the mandamus and cease and desist and
Yeah.
all these equitable remedies that are outside the Board of Adjustment's,
Right,
jurisdiction.
but by requiring them to enter into a subdivision agreement, they are subjected to the remedies under code.
Well, yeah, but the whole question at this point is, should our motion, if passed, become a further condition, little J, of the preliminary plat for 18 months? Or should it be a separate paragraph altogether that starts out by saying, the final plat shall not be approved or filed until you have entered into this subdivision agreement? Can we say that?
You can certainly say
I
it
think we
about
can
the
say
final
that.
plat approval. I don't
Yeah.
know what you can do about the preliminary plat approval.
Well, what happens if they never file for a final plat? They're already out there.
Well, then somebody, presumably the developer, will run into court and say, hey, court, enforce this.
Or go to the hearing officer under the independent.
Or go to the hearing office and say, hey, they were required to do this before they applied for final plat. They have been avoiding this by not filing for a final plat.
That's because the Heritage Land Bank is in control.
Well, make them apply for a final plat.
How do we do that?
Well, we can't do that.
Well, is there anything in code that allows us to nail them for a preliminary plat?
What do you mean? There is a preliminary plat. And the only question is whether we modify the conditions of approval of the preliminary plat.
Hold on just a second here. Under the preliminary plat, it's stated a subdivision agreement, right? Not an unrecorded subdivision agreement. There's something in there that's...
In the title search.
No?
No, it's not in there.
No, it stated something about, I asked a specific question about that.
Right, and that's one of the exhibits
There you
that's
go.
on file is
Yeah, there's a reference to an unrecorded subdivision agreement.
The certificate of plat exception,
Yes.
16R.86 reads as follows.
right, so that's something that when you go to
When you get a
when
certificate,
when you do, just like examining titles or
Yeah.
something, and so it shows up on the record, but you don't have that in front of you.
no,
You don't know if it was ever
I understand, but
executed.
here's the question, is that there's something about a certificate of plat,
Yes.
okay?
It's a condition to getting the final plat approval.
And it was a notice, it didn't record the subdivision agreement, it shows that what was recorded was a notice of the terms and conditions.
Okay, so basically,
subdivision.
as I understand this, okay, the location where the school is located is not a legal parcel until there's a certificate, until there's a plat.
Correct.
which has been approved,
Yes,
an approved plat.
yes.
So basically, if they're out in Never Never Land until such time as,
Well,
this whole subdivision doesn't take place until there's a final plat.
except the planning board blessed it by saying, we don't want to hold up the opening of the school. Remember?
Exactly. Big
That's
mistake.
why I said they dropped the ball by allowing that to happen.
I agree, 100%. So now they are required to enter into a subdivision agreement before a final plat is filed or approved.
Yes,
And if that's the case, then they need to enter into a subdivision agreement.
Yes.
And if not, then the muni they can cancel the plat, they can cancel the whole goddamn thing.
well,
They can cancel it all.
so can an aggrieved party.
Sure.
So then the question comes down, the motion that is pending, should that be a
Amended.
condition, an additional condition to the preliminary plat for 18 months? Or should it be a separate condition altogether that refers simply to the final plat? That's really the question. It's the only thing we still need to resolve.
Okay, so a separate condition?
It's either a separate condition to a preliminary plat. The objection that I have to that is that we already resolved that you can't have a subdivision, you cannot require a subdivision agreement before the final plat.
All right, then why don't you make it a section 3?
Yeah,
Well,
you can.
that's
Yes, you
the
can.
alternative.
It says before a final plat.
Can
For a
be recorded
subject to the-
for a subdivision where improvements are required,
Okay.
is approved or filed.
Yes, so in other words,
The subdivider shall enter into a subdivision agreement.
okay, so the entire motion then is not directed to a further exception to the preliminary plat. It simply is a specific statement that before the final plat can be filed or approved or filed, there needs to be a subdivision agreement, et cetera, et cetera.
That's right.
Okay. All right. I think we've got this hashed out. Does that make sense, Julia?
Yes, it does.
Okay, all right. So then let's restate this, and we all need to work together here. The Board of Adjustment substitutes its independent judgment on matters of law and related facts supported in the record by substantial evidence and modifies the Planning Board's 2014 decision by adding paragraph 3 to read as follows. Before approval or filing of the final plat,
Why are we putting it paragraph 3, Baron?
because it is not part of the preliminary plat. Okay, we just went through this.
You're
So
avoiding-
don't confuse me here.
You're avoiding the preliminary plat issue. You're sticking with another condition.
Right.
So it can't
To
be
read as follows.
the same thing.
ESD shall enter into a subdivision agreement with the municipality of Anchorage pursuant to AMC 2108060 to provide for completion of ASD project number 865007, in parentheses, Yosemite Drive upgrade, as described in section 1A of the development agreement of March 22, 2013, between the Anchorage School District and the municipality of Anchorage, and provides for the subdivision agreement provides for PM&E project number 5.4, in parentheses, Yosemite Drive drainage improvements, close parentheses, as described in section 1B of the said development agreement.
Are you going to include a section and other requirements as?
No. They shall enter into a subdivision agreement pursuant to AMC 2108-060.
Right.
Okay, that works.
Yep.
Okay, so we're all on board on this?
We're all on
Yep.
board.
Any further discussion?
I want to discuss it now.
Let's vote.
How do you vote, Baron Gutschall?
Yes.
Robert Stewart?
Aye.
John Haxby?
Yes.
Okay. The motion passes 3-0. Now then, now that we have required them to do that, do we even, and Julia, you need to help me out, do we even need to address issues 6, 7, and 8? Do we need to address them at all?
Baron, back up a second. Your language in this last motion said before a final plat
Yes.
is approved or filed.
Yes.
Correct, okay, got it, okay, good. So what are the other issues that we were looking at?
Well, we have not addressed issues 6, 7, and 8, and my question to Julia was that considering what we have just done, do we even need to address those? Or should we summarily just,
Well,
just to cross Ts and dot Is? Would you feel better if we did that?
I think that because of the insight that this board has worked out in terms of reading the Supreme Court decision, and to the extent that it did or did not incorporate, that distinction that you made about that it incorporated what needed to be done on how to do it, then I don't think that you have to go through 6, 7, and 8.
Okay, that, frankly.
can I discuss? Can I do a little discussion on this?
Yeah.
LBJ brings up a good point with respect to, look, the only hammer I got is that they're operating, they've got a certificate of occupancy.
Do they have a CO?
I assume they are because they're open, or they've got a conditional. Now, that is in violation of AMC 21.
Well, that's not our,
Well,
we
is
don't
there?
know. We don't know.
Okay, well, I can tell you what, you cannot occupy a building without a conditional certificate of occupancy, conditional or CO. You
Yep.
cannot occupy a building.
Yeah,
You're in violation of code.
right.
So, I'm not sure if you could just walk by them.
Why not?
Well, because LBJ could theoretically go up and say, look,
Yeah, that's up to them.
they're in violation.
That's up to them, that's not up to us.
Shut them down.
That's not up to us.
Okay?
That's, and as Julia said in the memo, there are various remedies that aggrieved parties have. They can go to the hearing officer, as Bob said, they can go run into court and say, hey, you've been required to enter into a subdivision agreement here before you get a final plat. What's going on here?
Yeah, and
So they can do all kinds of stuff.
Yeah.
That's not up to us.
Okay, all right, I'll buy it.
Julia, I have a question
Yeah.
for council. Julia, would the conditional occupancy show up in the title search?
The
The title
CO.
abstract?
I don't know if they issue a CO, I don't know if they don't record those.
I don't think so.
Right, what they're saying is the same answer that I would have, is that I don't know that the certificate of occupancy would show up in
No.
the recorded title. And I don't remember if are you thinking about that certificate of plat, on whether it showed up on the certificate of plat?
Yeah, that's what you
So a
said.
CO wouldn't show up on that.
I don't think it would.
No, it does not.
No.
Well, we can look
No.
and see.
No.
I can
So,
almost guarantee it.
yeah, so,
But I think that, you know,
but we don't need to concern ourselves with that.
well, and the reason why that is that, and this is discussed a little bit, you know, as just the underlying boundaries of the board's jurisdiction. You know, this board doesn't have jurisdiction to enforce a subdivision agreement, to
No.
enforce provisions of Title 21. And I'm not sure that you have enough evidence in front of you in the record to be able to make a finding on it, because that's the other thing, sometimes you can make a finding, but if we
Yeah.
don't know what the record has, then you're, you're
Yeah,
kind of beyond the record to be making a finding.
I think we've driven home they have to do
so,
a subdivision.
so now that we have required this to be included, which is really a conclusion, that's no longer a finding of fact, is it?
That's why you did it as a, substituting your.
Own judgment.
On a matter of law and stating facts. That's why it's a mixed question of law and facts. I think, as for all the facts that were woven into it.
Okay, so are we coming now to the conclusion part?
Of the decision?
Yes.
Yeah,
Okay. And what should the conclusion say?
well,
We want to be really careful on this.
The conclusion should say, the decision, and I'm just speaking out loud here without, the conclusion is that we are modifying the planning board decision of 2014. That's why I'm saying our last motion that passed is really a conclusion, because it flows from all of the other motions that we have passed, denied, what have you.
so I
Isn't that
think
true?
I think that that's true. I think that, that this also goes to the, sort of the question that I broached a bit in the beginning, is the form that your decision takes may be, a set of conclusions, which would be that, about whether, how are you going to address the decision of the planning board? And in some of these other motions that you've had, that you've been making, they're conclusions of law also. And so I would envision something that, that the minutes that the clerk reflects on the motions, something that would be supported by those, but would be, just as the other one, as the underlying one that we looked at from 2005, it would be findings and decision. And it would go through a set, and one of them would be, that you affirm the
Planning board decision except
with
for,
this modification.
As modified.
And so I think one of the things that you want to do before we, or as you enter into this stage, is to look at the planning board's decision in the record and see if there's anything else in there that is of trouble, because or conflicts with any of the other findings that you've made about, the case.
well, let's go through this, and let's look at it. I'm looking at section A on the first page. Approval is the most efficient. What's this within legal testimony? Drainage concerns will be addressed in the design phase. The intent is to move forward. Drainage improvement, 12-3. That's fine. Board approves the plat. Approval?
Hey, Baron,
Yeah.
does their condition, if you look at the beginning of this,
What page are you turning to?
163,
No. We are looking at the decision of 2014 now.
yeah, and that's what I think I have here, is the beginning. Second, let me see. Oh, you're looking at 2014?
Yes,
Oops, hold on.
2014-006.
That's in your record, that's
Page 13.
13 of the record on appeal, which is the decision that's under appeal.
What page?
13. So one thing, perhaps you can just, what the board has done is dived in, because your focus really has been on the approval of preliminary plat, not on all the other things. Nothing in page 1
Right.
or B1 was really brought up on this appeal. So you can say with, respect to, or that the Board of Adjustment affirms the planning board's approval of the preliminary plat for 18 months with the following modification.
Well, it's not just the preliminary plat. Look at paragraph B1. B, the board approves the plat. Is that the final plat or is that the preliminary plat?
Well, because it's, let's see,
It is a preliminary plat, isn't it?
yes, because that was what,
That's what it's supposed to be.
Right.
yeah.
So,
So you may want to make some adjustments in.
Hold on just a second.
approves the plat. See, there's something odd here. When you look at 1, it says, the board approves the plat subject to the following conditions. 1, approval of the request to vacate is subject to, and then it says, approval of the preliminary plat for 18 months is subject to the following conditions.
Okay, so maybe you want to start at the beginning and say, after some whereases in the decision, say now therefore be it resolved, the Board of Adjustment adopts the following findings and decision. And then you go through and you just repeat the ones that make sense there. So the Board of Adjustment affirms findings of fact as follows, and you have approval of this preliminary plat is the most efficient process. You have the testimony, then the drainage concerns will be addressed, sort of
Why should we do that? We just simply incorporate, we just say we approve of this decision, we simply add a third one.
Well, hold on.
You
Look at
pointed out
this.
that perhaps some clarification, I may have misunderstood you, but I thought you were pointing out that some clarification may be needed because they're talking about the above-mentioned plat approval, and it's not distinguished
Okay,
that it's an application for preliminary.
Look on page 14, number 2. Approval of the preliminary plat for 18 months.
Right,
Right.
right.
So it's preliminary. So this is a preliminary, it's not a final, it's not.
The preamble to B should say the board approves the above-mentioned preliminary plat.
That's correct.
That would be consistent with
With 2.
But when you look at the very first whereas, when you look at the very first whereas, it says, for approval of the subdivision, that's not inconsistent?
So
Well, approval of the sub,
Or is inconsistent also.
It's approval of the subdivision. I mean, basically, what's happened here is that there's a little bit of language. Was the preliminary plat,
The application is included in your record, and so that's what I had to do. I had to go back and look
So
at the
what's the application say?
And my recollection is that the application is for preliminary plat approval, because, as you pointed out earlier, the preliminary plat expired, there was all that stuff in the record about
Right,
how
right.
instead of putting in a new, instead of extending for another 18 months, they were out. You know, you only
Preliminary
had
plat,
two
28,
extensive.
page 28 of the record on appeal. It's just a drawing of some sort.
Oh, okay, on 32, it's a application for preliminary plat,
what's the date of that?
Oh, yeah, there it is.
February 5,
Right there.
2014.
Yeah.
Okay, so we call this the preliminary plat, and so going back,
So I think there are things in A that.
so we need to insert,
Also.
in A1, we need to say preliminary plat.
Yeah, approval of this preliminary plat.
Yep. And in B, the preamble, the board approves the above-mentioned preliminary plat. Okay? And we leave the rest of B1 and 2 the way it is, and then we add, instead of what we said in the previous motion is paragraph 3, we simply make it capital C. Subdivision agreement requirement. Okay? Before approval of final plat, before approval of filing a final plat.
Before approval
That would work to see.
Before approval or filing of final plat.
So it's, the language is approval or filing. Okay. Does that make sense?
Yeah.
Yeah, it works better under C.
Yeah. Okay. So that is our decision. Did you follow that?
Yes, I think so.
Okay.
So let me just.
So our decision is that we leave in place the Planning Board Resolution 2014-006, except that we amend it as follows. In A1, we add the word preliminary before the word plat. In the preamble to B, we add the word preliminary before plat. And we add a paragraph capital C, and that is what we previously,
Previous motion.
that was the previous motion.
Yes.
And I have a question
Okay?
on the board's preference. Is the board's preference that I just note the 3 modifications, or is the board's preference that I incorporate them like we do with, you know, S versions?
Also
and
that you
show
would-
it, so you have everything in
So
one
you
document.
regurgitate the whole thing.
Yeah.
That's
Yeah,
really what
put it
it
in one
is.
document.
I think that would be better,
Yeah.
considering that this is so controversial anyway, that we should make it as clear as we possibly can.
I
Yes.
think that that's an
Yeah.
excellent idea.
Okay?
So let's just make it into the resolution, and that's
Yes.
our decision.
Okay?
And then it's all cleaned up, one document, nobody has to keep going back into 50 different pages, I agree with that.
So, I will move that we pass a decision, that we approve the decision as described by me a minute ago. How's that? Just so that the record is clear. Second?
Second.
Okay, Mr. Hagsby. All right, I think we have sufficiently stated our intention, and it is clear that what we are really wanting to do and have wanted to do here is to make a slight modification and clarification to the Planning Board's Resolution 2014-006 by cleaning up a possibly confusing referral to final and preliminary plat, and by inserting paragraph C, which was the subject matter of the previous motion. And that's what it should be.
Did you get all that?
Yeah.
Everybody, any further discussion on this?
No, I'm comfortable with that.
Okay, good. Madam Clerk?
How do you vote? Baron Goodchow?
Yes?
Robert Stewart?
Aye.
John Haxby?
Yes.
The motion passes 3-0. All right. Anything else we need to address on this particular one?
Do we need to whack out those last couple of sections that we're not going to address?
No.
Do we need to formally,
No. We simply
need to state we're not going to address these?
We simply state on the record that we are not addressing issues 6, 7, and 8.
And I mean, that's, you get to do that. That's a confidential memo, that is a bench memo.
Yeah,
Those
don't
are
need
the
to-
I don't think we
issues
need to do that. No.
that I saw
No, we
that, so
don't.
I don't even.
We don't need to do that.
It's the only
Because
one
those were
we,
not
it's
issues.
the only one we totally agreed on, and so we should, they have a thing in there.
That's not
They
true.
have a thing in here where they can resolve the naming of
So-
the subdivision. That's big who shall.
Okay, so now, what else? Do we need to do anything else? There is the usual stuff at the end of our decisions that gives the notice of appeal, et cetera, and you're familiar with that.
Yes.
And I don't think we need anything else. We then simply, as next matter of business, we need to find out when we are going to gather again. When can you have this hammered out?
Let's ask Lisa when the motions, when she'll be, because I will need to use the decisions of the board, so, and the stated motions, so.
I can get them done as quick as you want me to.
Tomorrow is
I mean, I can
Thursday.
start working on it.
Could you?
Tomorrow,
Here's my
and-
problem. I am leaving town on the 21st, and I would like us to, that's a week from this last Tuesday, from yesterday, 2 weeks from yesterday. I would want to be sure that we have this, the final decision signed off before I leave town. Can you do that?
Yes,
Before the 21st?
yes,
Which is
so
in 2 weeks.
just, you think that you'll have them done by tomorrow?
I'll do it, make it my priority tomorrow, and try to have it done by the end of the day, if not before.
Oh, excellent.
Okay, and so,
What's your schedule?
so my schedule is crowded, but I did a lot of work on this. And so, and one of those things was to already have the decision of P and Z retyped. I mean, of the planning board retyped, so, you know, I don't have to start
Yeah.
with that. And so we have
Yeah.
the notes, and so you made findings, and I'm dependent on her for the findings, so I don't think this will be, you know, too
Okay.
bad.
So, how would next Wednesday?
That'd be great,
Could you do that?
absolutely.
Are you available next Wednesday at 5:30?
Hang on.
We need to vote on the final written decision. Okay. Remember?
Oh,
It's on the 15th.
just a second. So
Yes.
next Wednesday would be the 15th? Yeah, I can do it.
Okay.
Question.
Yes.
Can you notice us, please?
Yes.
Just so I don't forget it.
Do do we still need to append the 3 documents that we were talking about earlier for reference in our decision?
Oh, absolutely, they should be incorporated, and I think...
Okay, no problems with that.
No
Yeah.
problems with that.
Okay?
Now, I can have that prepared for you in
Thank you.
advance of Wednesday. I know that I
Yeah.
have a conflict on Wednesday
Uh-oh.
night, and I just don't know how late that conflict is.
So would you want to meet a little later?
No, I would want to be a little earlier,
Ooh.
if at all possible, so
Well,
that I could.
when would you want to meet? Let's talk about that way first. What's your druthers?
Oh, something like 4?
Can you do it at 4?
Yeah, I can do it.
Can you do it at 4?
Hey, I'm flexible.
Is
I can
the
go
parking-
earlier if you
Okay.
want.
Is the
Yeah.
parking free?
Flexible.
Yes,
You-
parking's free
So
at
we could get a parking spot
4,
right
yeah,
here?
and then you don't have to,
It's 2 hours free.
yeah. Actually, it's free, it'll be 2 hours free because at 6 o'clock the parking kicks in,
Okay.
yeah. So
Just
as
always-
early as anybody can meet on
You mean you're
Wednesday,
too
that
cheap
would
to pay
be,
$1 to park over there in the garage?
Dude, you know, after running as many hours as we went through on this thing, number of man hours?
This takes half an hour to approve this thing, max.
No, I'm talking about what we've been through. Come on. I
Yeah.
want my dollar.
We used to get $50 per meeting, by the way.
Did you ever get an answer to your letter to the assembly?
about the budget.
Oh, yeah, he says, oh, yeah, there is a budget. Oh, I won't send it to you. I got a long reply from Pat, and he says, oh, there is a budget. You don't need to worry about it. There's a budget.
Okay? Show me the money. Robin says I love you like a check.
So, Madam Clerk, there's an inquiry here as to when we are seeing our $50 per meeting.
Oh, I will write that question down.
If they're gonna send you $10.99,
For Barbara.
You certainly earned it on this one, I'll tell you that.
yeah, so we got paid a penny an hour. You know, we-
So, okay, in all fairness, we need to get back to the agenda.
Okay.
We have set the date. Next thing is member comments. Are there any comments that either one of you have? I don't have anything.
No.
Mr. Stewart, do you have anything?
None.
Okay. Then, audience participation. You may now participate,
All present.
but you may not include argument or testimony or other evidence, and you may not discuss in any way or bring up the case that we just decided. So is there any audience participation? Seeing none?
See no audience.
Seeing no audience, there cannot be any audience participation, and unless there's an objection, I suggest we are adjourned. Thank you very much, and I want to thank both of you for hanging in there with us for all these hours tonight.
Yeah,
You
we
ladies,
got up early.
so we're getting off early.
Till 10, did you?
I suggested 10 o'clock.
Started awful slow.
You ladies did an
I know.
awesome job.